Welcome, guys. We are sneaking in tonight. Going to have an emergency team meeting. So I hope you guys had a great day. And we're going to talk about some stuff today that we need to get on the record. And some people need to catch up. So tonight, let's start with the formalities. Welcome to Advocates for Justice, Foreclosure Defense Paralegal Service. We are different and we prove it. I'm Coach Neighbors. I'm the one with the whistle up in here. You guys know me already, so I won't spend a whole lot of time on me unless you guys want me to. Okay, I'll move forward. Tonight, we're going to have an emergency team meeting, and we're going to review the way you should be using your jurisdictional challenge with an affidavit. And we're going to talk about how you need to challenge jurisdiction, because there's a lot of things going on, and some of those things are just because we don't know. So we're going to try and get that figured out so that you know. And then if you do the stuff and you know, then it's not. Then you're going to be on the bench. To the bench. Okay, sorry, got a little carried away with the bench thing. So let's get right down to it. When you challenge jurisdiction, okay, let's just start from the beginning. When you challenge jurisdiction, you cannot argue their banking system or anything else. If you challenge jurisdiction, you can only argue what you have in the jurisdiction. If you allow them to argue anything else, or if you start arguing the banking system or the servicer or any of that stuff, then you are giving them the right to bypass your jurisdictional challenge with an affidavit. Because if you put the jurisdictional challenge out there, then you throw some more stuff out there, then they don't have to answer to the jurisdictional challenge because you got this new stuff and they're figuring you're bypassing your challenge. And I had a couple of people in the group last week that were talking about that. And one person changed the jurisdictional challenge with an affidavit and removed the affidavit. And I was really stressed out about that, because the document is designed to put you in a particular situation to force the judge to allow the attorneys to go through without and violate their laws, the rules. And that's what it's designed to do. So if you remove the affidavit, you're shooting yourself in the foot, just plain and simple, because with the affidavit there, it interferes with the judge being able to just throw it out legally. And the attorneys cannot respond to it by counter affidavit, because everything they're doing is fraud and they're lying. And they can't sign that counter affidavit addressing that. I have not had, out of all the people that are using it, the jurisdictional challenge with an affidavit, not one time has an attorney responded by counter affidavit. Not one time, because they can't. And that's the beauty of the documents that I put together. We put the shit together to back them in a corner and show you how to use their own shit against them. And that's what we're doing. If you remove the affidavit out of the jurisdictional challenge with affidavit, then you're just shooting yourself in the foot. Because the way that document is designed, it's designed to put you in a position to have a nice appeal, if you wanted to appeal, while you're getting your lawsuit filed on the record. Because what happens with that affidavit, with that jurisdictional challenge with an affidavit, is the attorneys can't respond to it. The attorney can't, when you add the attorney to your lawsuit as an M1 defendant and their law firm as a second defendant, that creates the first serious problem. And the attorneys can't respond to the jurisdictional challenge with an affidavit because they can't respond by counter affidavit. And they can't prove jurisdiction to the court because the court's doing the foreclosure based off of a statute, and that statute does not have the necessary elements to be considered a valid law. The statute that they used for the foreclosure does not have an acting clause, it does not have a title, and it does not have a body, and it is not legal. The issue here is if if the statute they're using to foreclose with is not a legal, is not a binding, it's not a law, it's not a valid law, then the court don't have jurisdiction to be messing with your stuff or doing any of that. But people bypass this, and when you get to court on it, people don't understand the power they have, and a lot of the times people let the judge and the attorney get them off track. The judge wants to talk about the payments. She wants to talk about the payments, because once you agree to the payments, about the payments, then the judge can move forward. In her mind, when you start talking about the payments, you have admitted that there was a contract, even though there is no contract. And what they filed in court is not a contract because it's only signed by you. The lender never signed it any place. And the only thing that's on the petition that's signed is what the attorney signed. Now, this is the thing that most people don't realize and they mess up on. The attorney's not working for the lender. Okay, the lender didn't sign anything. The lender's not involved in this. The attorney is doing this, acting as a third-party debt collector. That's what time it is. And that's why we add the attorney to the lawsuit as the number one defendant and his law firm second. And when you do that, you block the attorney from representing himself or the law firm. The attorneys can't litigate a case they're a party to. They can't represent themselves. And most people don't know this. The court rules will not allow them to go into court and represent the corporation they work for. Corporation cannot represent itself in court. And that's a problem. Now, we have this set up. If you file it the way it is, when you get it, you'll put yourself in a position to force the judge to let the attorneys escape the rules, because the attorneys have to hire outside counsel when you do this to them. And that's a problem because they have a hard time finding someone to help them, because the other attorneys, when they go to get them to help, find out that you're suing this attorney and the law firm for foreclosing on you, acting as a third-party debt collector without standing. And the other attorneys don't want anything to do with that because they know the cat's out of the bag. And if you do this the right way, you will be driver of the bus. I'm telling you. Once they find out that you're suing them for unlawfully collecting a third-party debt collection, as the foreclosure is based off a third-party debt collection, that's a problem. And they're not going to want to help them. Now, the judge is going to have to let them go in court and represent themselves and the law firm and violate the rules. Otherwise, the judge is going to have to get back her cut or his cut of the take, because you know they already got your property split up. They're not waiting for all this process to go down before they start taking your stuff, because they're out of control and they're used to doing whatever the hell they want to, because they know that 80% of Americans don't trust attorneys, and probably the same amount can't afford attorneys. So, and anybody that has an attorney will find out that anyone that has an attorney will find out that you could have messed up your case by yourself. Yeah. So the main thing, when you're challenging jurisdiction, whether you're using a jurisdictional challenge with an affidavit or one of the other 3 or 4 jurisdictional challenges that's in the package, you want to make sure that you don't allow them to ignore your challenge by talking too much about stuff that don't matter. A lot of times people will file my stuff, they'll get themselves in position, but then they haven't studied. They have not studied the stuff. So they really can't blow it off their tongue and stick it in nobody's face. And that's sad, because when most people get in that situation, you revert back to what you can blow off your tongue and stick in their face. And that's the same shit that they already told you that you know ain't going to help you. And if you start talking about that stuff in foreclosure court, the banking system and all that stuff, show me, and all that stuff, you're going to be doomed. That's what they want you to talk about. I never send anybody into court to talk about what they want to talk about. If they're going to drag your ass in court, we're going to talk about some other shit they don't want to talk about. That's the way we roll with that. It's kind of like Do you answer? Or do you respond to their position? Well, there's a big difference. Okay. When you answer, you're answering to the fraud they said that you did. Okay. And you already know it, the whole thing is fraud. So that ain't going to help you. You can answer all you want to, and you're still going to be standing in that pile of crap at the end of the day. When you respond jamming them up, okay, because they're the reasons for the fraud. So instead of going to court in foreclosure court defending yourself from what they said, you want to go into court on offense, jamming them up for putting you in the position that you're in right now. That's the way we roll. Now, the last thing that you want to do is file your stuff and go sit down and wait for the damn judge. Okay, I got people doing that, driving me crazy. Now, I realize I don't have time to tell you guys everything that you need to know. So you guys need to be spending some time figuring some shit out yourself. You need to spend time in the Facebook page group, looking at what's being posted, looking at what other people are saying, looking at what we're talking about, how the changes that we need to make to the jurisdictional challenge with an affidavit. A couple of weeks ago, I think I made 2 videos talking about the jurisdictional challenge with an affidavit and how people were allowing the judge to answer because they were going to just sit down and not pay any attention to the time frame that these fools have to respond. So if you don't know when they're supposed to respond to your document, then you don't know when you need to jam them up. So you're just going to go sit down, and then what happens is when the time frame passes that you should be filing your motion for default, when that time passes, the judge takes over because the judge is assuming you're waiting for him or her to throw your ass out because that's what happens when you allow that. If you spend any time reading the jurisdictional challenge with an affidavit document, you will find in the first couple of paragraphs what you're doing is you're demanding the judge to order them fools to prove jurisdiction on the record. Now, I don't see how anybody could be happy if the judge dismiss your shit and answer for them. Oh, hell no. No. Even if you didn't follow through and they dismissed it, and the judge dismissed your jurisdictional challenge on affidavit, the judge is liable. Now, if you went into court and you start talking about arguing a bunch of other stuff and some case law and all that stuff, then you can't really sue the judge for them ignoring your jurisdictional challenge with an affidavit because you ignored it and passed it up for this other stuff that you think is more important. And that's why it's good to keep your mouth shut and stick with what's on that paper. What's on that paper is what got you in the hearing because they need to have the hearing to get you under control. Hello, Erica. And I have another person here, a Facebook user. The people coming from Facebook, I don't see their name. So if you log in and I say, hey, Facebook user, I'm talking about you. If you just logged in, because when I'm using StreamYard, I don't see the name. But the beauty of using StreamYard is I can stream in all 5 of my Facebook pages and on YouTube at the same time. And that's pretty remarkable. So I kind of like using it. So you guys have to check the time frame to see what the time frame is they have to respond in. You need to look up the civil rules of the federal rules of civil procedure on the internet and save it. And you need to go to that publication and look up the rules and the procedure for each process that you're in. There's a procedure for the process of service. There's a procedure for pleadings and filing your pleadings. There's a procedure for answering the pleadings. There's a procedure for everything. Now, the reason you should go, I had a lady tell me today, well, I'll just go to court and look at, no, don't go to court and look at shit in court, okay? Because when you go to court and you look up the stuff in court, you're going to be looking at the local rules, okay? The local rules are the rules that the court put together for themselves, for the attorneys, and for the clerk, and for the judges. And in my opinion, those local rules are designed to speed the process up and hurry up and get you through court. Now, you already know if they're hurrying your ass through court, you're getting screwed, right? Yep. The local rules have not the local rules, hello, Ashmin, the local rules have not been passed through legislation, legislation, well, whatever the hell it is I'm trying to say. The local rules are not in line with the Constitution, and they have not been passed through legislation. So you're not liable to follow those rules. And anytime they tell you are, I would just tell them, look, my legal team already looked up the federal rules of civil procedure, and we have followed those rules. Or if you file it in state court, I would tell them my legal team has already looked up the statute for filing requirements for this state, and my document is within that statute. If there's a problem, then you need to let me know, and I'm going to need your bar number and your name, so my legal team will know who I need to add. You know where I'm going with that. I have people all the time. You want to tell them your legal team. You want to jack with their heads because you do have a legal team. I had them ask them. They asked this lady one day in court who her legal team was because they did not like the documents that she took to court. And she was ready for them because I told her they would ask her this. Of course, she didn't tell me what she was going to say. And she called me later. She was laughing. So I asked her what she told them. She told them her legal team was God. They ain't messing with that. They ain't about to talk about God in that little Satan's den of evil, stealing people's shit and kicking people out on the street. No, they shut the hell up quick. Yeah. So you need to make sure that you know when they're supposed to respond. You need to make sure that you have the document that you need to stick in their face when they fail to respond. Because I'm telling you right now, they can't respond to the jurisdictional challenge with an affidavit. Not one time has an attorney responded by counter affidavit. Now, there's been a couple of sorry-ass responses, but yeah. And most of them were done by the judge. And most of the people that used it got no response from the attorney at all. And sadly enough, some people didn't do anything in time, and then the judge took over, and now we're playing catch-up, going after the judge to make the judge straighten up. So you can make it a lot easier on yourself if you spend the time, and that's the number one thing as a coach that I'm going to say. Number one thing, people don't spend enough time. And, I realize that I'm the only one that this is all I got to do all day. So, so I realize that. But when it comes to standing and keeping the roof over your family's head, you're going to need to make the time. And checking the Facebook page, seeing what's been posted, checking the videos. Now, when we talk about the videos, I want to point out a couple of things. So my YouTube channel is sectioned in playlist. There's a playlist for a jurisdictional challenge. There's a playlist for attacking a judge. There's a playlist for tips and strategies in court. There's a playlist for the instructional videos for the lawsuit packages. So when you go to my YouTube channel and you look at the title, the first part of the title is, the title is always in two parts. The first part of the title is what I use so YouTube will rank my video and actually show it to people, okay? The second part of the title is actually more about what the video is about or whatever. So don't pay a whole lot of attention to the first part of the title. It could say non-judicial foreclosure in California. Well, that's going to be good for any state that has non-judicial foreclosure, not just California. But when you have a small channel, you have to do things this way or no one will ever see my videos. So that's the way we do that. And if you go to my channel, I think at the top of the page is a search window. And if you type in jurisdictional challenge or how to recuse a judge, it should pull up the videos that you want to look at. That'll help you get around instead of having to look at all, search through 126 or 27 videos that I have posted. So that's just a little bit of a tip on that. So you guys want to make sure you use the federal rules of civil procedure to understand the procedure for each step of the court process that you're involved in. Now, I'm not an attorney, so I don't know that stuff. I'm kind of learning as we go the rules, and I know a little bit, but if you don't learn the stuff yourself, you're not going to be able to stay in your house, basically, because we're not trying to win. We're trying to stay in our house. That's our goal, to get to stay in your house. So Erica's talking about her, we can talk about that, Erica, in their Facebook page. I'm going to leave this for our education, and we can talk about everybody's stuff in the Facebook page. It's a lot easier for me to talk about it in the Facebook page because I can type and read instead of looking in the camera and trying to remember what I got to say, and so that's going to work out better for us. And I'll be in the page later tonight after the stream, not right after the stream because I have some things I have to do. I have to take my lights down and clean up. But I will be in the Facebook page after the stream. So if you want to talk about your situation, we can do that. We can do that then. So the local rules are the rules that you don't have to follow unless you just want to throw yourself under the bus. So you want to make sure that they're not tricking you into following the local rules. You need to make sure you understand the document, and your conversation with the clerk should reflect what's in the document. People don't realize that the clerk is picking your brain to figure out if you have any freaking idea what you're doing. And if the clerk figures you don't have an idea what you're doing, well, you know what they're going to do. Okay, they're going to send you on a wild goose chase, and they're going to tell you that you need to put a dot over all of these I's, and you got to do all this other stupid crap because they're trying to make you follow the local rules and not the actual statute for requirement for filing in the first place. So now, one of the things that I want to talk about too is why it is we don't add everybody on the list that they add. Okay, they add all of those people on the list. They only do that to screw you over. Think about it. All of those people they add on the list already made their money. They only put those people on there to confuse, to muddy the waters and confuse you, and to make your life hell. Number one, the more people you have on the lawsuit, the more people you got to serve, the more people you got to respond to it, to respond, and all of this stuff, and it's crazy. For me, I like to add the attorney who signed to initiate the foreclosure against your shit. I like to add the attorney's law firm and the last servicer, because the servicer claimed the alleged loss on their, they done a charge off. They claimed the loss on their taxes and they wrote it off to insurance. And then they turn around and sold this alleged debt to these third-party debt collectors. And that's how they got involved in it. So the servicer violated federal laws by selling the debt after they charged it off their books and wrote it off their taxes. Okay, let me think. That's called income tax fraud and insurance fraud. Income tax evasion and insurance fraud. Yep, that's what it's called. And I know that because anybody who understands GAAP accounting principles will know that once you do a charge off and once you claim it on the insurance on your taxes, it's done. There's no entry places to enter any additional income from that situation. Yeah. So that's how they do that. We add the attorney, and what you want to do is you want to force the attorney to take the heat for everybody else's crimes. Because we already know attorneys don't have a spine, and they're not going to take the heat for everybody else. So now you're going to create a rift. And now attorneys are wondering, why should I be taking the heat for you guys? And the other people that's involved in this are going to be telling dudes, you need to get this shit under control. That's your job. And and now it's time to have a little fun. These real estate thieves work in packs to commit these crimes. So all you have to do is jam one person up and make that one person have cold feet. And that would be the attorney, the one that's being held responsible for everybody else. Yep. And once you do that, now people are going, wait a minute. Attorney's going to be whining about taking the heat for everybody else, and everybody else is going to be in their face. Yeah. This is the kind of thing that we like to teach people how to do. Remember, you always want to state that you reserve the right to amend your pleadings. This way you can add anybody you want. I always leave that on there. Reserve the right to amend, because you never know if you have to go to trial how many more people you're going to add on there. But I wouldn't add them at the beginning. I would only add what I need to get done what you need to do. And that's to hold the person that signed to start the foreclosure against your property liable. And at the end of the day, you're going to be holding the judge liable too, because the judge is going to, if you take my fire to the stinking hole, the judge is going to have to help them. Now, if the judge dismisses your jurisdictional challenge with an affidavit, then you can sue the judge, because that's a problem. Okay, because right in the document, you're stating that the judge is supposed to make them respond. The judge is not supposed to respond on their behalf. So, but if you go into court and you start talking about a bunch of other stuff and not what's in the jurisdictional challenge with an affidavit, and you allow them to turn the corner on you, then you really can't sue the judge, because it's you shot yourself in the foot. Now, for the people who shot themselves in the foot, okay, what I would do is I would refile the jurisdictional challenge with an affidavit and stick it back in their face. And remember, you can challenge jurisdiction anytime, up to 15 years. So just because it didn't work out the first time, don't mean that they're off the hook. And when you file it the second time, sure, the judge is going to try to throw it out, and they're going to cut, and then when that happens, you have what you need to go after the judge, because you really can't go after the judge if you shot yourself in the foot and gave them a highway to slide out the back door. That's how I would handle that if it was me. And I would do that ASAP, especially if you're about to get pushed off the edge of the cliff. You want to make sure you're not shooting yourself in the foot by talking too much when you're nervous. And that's what most people do. And they know that. They know they can hear your legs shaking. Okay, let me be serious. I'm sorry, I got carried away on that one. But yeah, they can tell you're nervous as hell, and they use it to their advantage. And if you ever do have to go into court and you take my stuff into court and you actually have this, I would tell them, hey, my legal team put this together. I'm going to stand on my pleading. That fool can argue the pleading, and then we'll go from there. Thank you very much. Okay, I need to work on that, huh? Okay, sorry. Anyway, so that's how you want to handle that. You don't have to worry about being in the court, because look, at the end of the day, the judge is going to throw your ass under the bus anyway, and you're going to have to slap the judge in the face. And that's just the way it goes. That's the way it's going. And that's what we're doing right now. We're learning how to cut to the chase. And all of the rigmarole and the crap in between and all these hearings and all this crap, nah, we ain't got time for that, okay? We got a different program here, okay? I'm not charging you guys enough to hang around and keep sticking my hand in your pocket. We need to get some stuff done and get you guys moved over to the side, to the side of the road. So let me see. I'm just wondering if you were on the topic. Now, we'll answer your stuff, Erica, in the group, because if I start, then I have to answer everybody's. And this is, my live streams are about educating people and that. If you want to talk about your situation, we need to talk in the group. And it works out best, too, because when we talk in the group, then other people can see your questions and can see the answers. And sometimes people have comments that they can add to the situation, as long as they're comments that you've learned after you've been in the group. I don't really like to talk about what people's attorneys did or didn't do. And that's the last thing I want to talk about, and I don't even want to talk about that in the group. So I would tell people we're not looking back. Okay, we're looking forward. And where I see looking forward, there's no attorneys. So if they are, we finna stomp on their face. We're gonna get up in their face. Actually, I like to step on their neck. That's how but I don't want y'all to think I'm violent. Okay, let me be serious. Hey, Tim Larkin in New York. William Carrington, welcome, guys. Let me put a stream mirror across the bar. Oh, for you guys who have real properties and investments that you need to protect, we have a new online course. And that is the link to our new online course. I think I have 23 people enrolled in it already. It's half price right now at $1,200. So, and the online course has everything that's in my inventory that you would need to kick these people's butt. You have access to it, videos. I just uploaded 7 new lectures last month. One of them was very in depth in detail about how to state a claim, the proper procedures for stating a claim for relief. I got tired of them trying to stick that in our face, so I spent a couple of weeks learning how to do that. And so for the online course, I not only put the video together with a guide to help you state your claim. For the online course people, I actually put together my own state of claim and included it in video included in the course curriculum for the people who are struggling and about to get pushed off the edge of the cliff who just got in the online course. So all you would need to do is copy and paste it and put it in your copy and paste it into your claim. So all of the people that invested in the lawsuit packages, you can go to my YouTube channel and you can search state of claim for relief and pull up the couple of videos that I have on that, and you can get the guide. And I also, if I remember correctly, I copy and pasted the guide in the comment section down below. So you can copy and paste it in a Word document and print it out and just have it sitting there next to you while you're putting the information together that you need to put together. And I was kind of surprised because it was kind of stinking easy. Probably should have did it a long time ago, but we're doing it now. So, okay. Okay, so let me check, and I think that's all I had for tonight. I just wanted to come on here and leave this out there because, I talked to another person yesterday who actually changed the jurisdictional challenge and before he filed it. And so he's kind of struggling right now. So I hope he can figure that out and get that corrected. So I wanted to touch on that again because the jurisdictional challenge is a very powerful document. But if you sit back and you let the judge answer, you're going to be in trouble. So you need to be on your toes. You need to know the federal rules of civil procedure processes. You don't need to know the whole big old fat book. All you need to know is what you need to know for the step that you're in. If you're filing pleadings, then you want to go and review the section on filing pleadings. If you're filing your notice of claim or how to serve people or whatever, then you want to go and you want to check that out. You need to check that out for each process so that you can make sure you know what's going on, so you ain't leaving shit on the table that they're going to be using and throw your shit out with later. So. Joe Shitlip says, why can't we are turning the tables on them, but we need to understand how to challenge jurisdiction and how to stay in control of the hearing if you're in a hearing or on the telephone or in a video conference. And that's what we need to do. So. Well, dude, if you get a loan mod, it'll buy you time staying house. I don't agree with you. And I'll tell you why. The loan modifications nowadays are being used to disqualify homeowners. Yep. when you do a loan modification, you have to disclose to them all of your financial information, your assets, all of your stuff. And when they find out that you have more income going out than you have coming in, then they're not going to work with you no more. In my opinion, the loan modification process is being used to disqualify homeowners and to stall them. They will stall you to death. Oh, wait, you need to send this paperwork again. We didn't get it last time you sent it. We didn't get that. Back and forth, until they're knocking on your door with your crew to change the locks on your shit. That's how they do that. So for me, I would not waste any time. So there's conventional and there's non-conventional, okay? Loan modification is the conventional. That's what attorneys offer you. In the conventional program, foreclosure defense program, you have three options. You have your short sale, okay, we don't even talk about that. The loan modification, we just got done talking about that. And the bankruptcy. Well, the bankruptcy, most of the time, they never explain to you that most states have a deficiency judgment. And that means whatever balance is remaining after they give your house away, they can come after you for. They don't tell you that when you file bankruptcy. Oh, wait, there's a fourth option, move out. You had a lady tell me she spent $9,000 and an attorney told her in the end when she ran out of money, you don't know why she's fighting so hard. She should just move out. Of course, I told her I'm glad that wasn't my attorney. And if it was, that attorney better be telling me that after he's left the country. Yeah, because I would be in trouble if that was the case. MYX. Thanks, MYX Capital. I appreciate it. Now, I want you guys to be thinking about what I could do for subscriptions. My YouTube site is monetized, and I'll be able to charge people subscriptions and things. And so I need you guys to be coming up with some ideas on what I should give you for your subscription. What value I could provide for you guys for your monthly subscription. So we should be thinking about that. Maybe we'll talk about that this weekend on Saturday. So that's all I got, guys. Thank you, and I'll see you guys in the next video. And hopefully it won't be an emergency team meeting where I'm about to make everybody run. Good night.